so far as the central bank is concerned, well, they have very, very, very broad powers, and the Securities Commission very, very broad powers as well. And in my jurisdiction, the parties who are unhappy with the decisions have no issue taking on the stock exchange. But when it comes to the central bank and the Securities Commission, there's always that fear. There's always that fear. And there was, and I can say this, although the SC rep, who's actually a delegate here, she's not in the room, but I'll tell her. There was one occasion I was instructed by a client to challenge the decision of the Securities Commission, and immediately I got a phone call from someone, a friend of mine at SC, and said, "Why are you doing this?" You know, so we need a cultural change in my jurisdiction, and I think the same probably applies with Singapore. We don't have that many challenges to such authorities in these two jurisdictions. Yeah.
From a regulator's point of view, this discussion here is relevant in terms of the practical preparation of matters which go before the tribunal. The issues of whether a matter is heard de novo and the standard of proof, obviously critical for us to consider. I was interested to hear Michael Thomas say that if new evidence is presented, that you'd be minded not to include it.
Well, just to comment on this, because new evidence, it's not to be exactly what it means. I come from a different legal system.
Ah, okay.
New evidence could mean new evidence supporting the same findings.
Yes.
In other words, we have found new facts proving that he's guilty of this. Or new evidence could be we have now found new grounds for prosecuting him. Not only is he guilty of this and that, but he's also guilty of, I don't know, embezzlement.
Sure, absolutely. Which is what I wanted to discuss.
There's also the development of new facts, recent facts,
yes,
which tend to cast
subsequent
light
facts, yeah.
upon character
Subsequent facts,
or
yeah.
conduct.
That's also, but it will still be new facts, okay?
No, it's fine. Well, I wasn't thinking of matters which take you in an entirely new direction, which would require a whole new case, but maybe new factors which would, as you say, support what is there already before the parties, which the regulator has considered in reaching a decision up until its internal processes, and all of this goes towards the fairness of the process, because clearly the other party needs to have an opportunity to respond. It's entirely possible that during the course of a matter being heard at the tribunal that new matters arise as part of the examination and cross-examination, and provided parties have the opportunity to deal with that within that environment, they may be allowed by the panel. That's obviously a matter for them. So these are all issues which one has to consider in advance, as well as deal with during the course of the tribunal as the matter is progressing.